Welcome. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist serving Georgia, Florida, and Alabama. I want to welcome you today. We are talking about how to prepare for court, and I am so excited because I have a special guest with me today. My special guest is none other than attorney Shirley Millwood. And if you'd like to go ahead and greet everyone, Shirley.
Yes, good afternoon, and good afternoon to you, Miss Langley. It's a pleasure to be here. I am Shirley Millwood. I've been in Calhoun County, Alabama my entire life. I've been practicing law for more than 14 years. I've been in the legal field for more than 26 years. I started out as a legal assistant while I worked and went to school, and then passed the bar and started practicing law. I went into a rural area in Alexandria, Alabama, opened the first law firm there. That was in October of 2009. 14 plus years later, I'm still the only law firm in the rural area. And so this is what I've been doing for most of my life, is being in the legal field.
Awesome. Well, thank you. I am so honored to have you today. I know you're going to be a wealth of knowledge for us. And so let's go ahead and get started. We're talking again today, everyone, about how to prepare for court. And I am a probate real estate agent. And so I encounter a lot of times where people, I assist people when they're selling their homes, when their loved one has passed away. And just in the midst of conversations, a lot of times people are preparing for court. And so I saw the need to do this video. So I want to go ahead and get into the questions. How does an individual decide if, first of all, if they should attend the court hearing?
First of all, it's going to be whether or not they are in agreement. I'm assuming you're talking about, kind of court hearings in general, or specifically for probate hearings?
Probate hearings.
Okay.
Yes.
So if they are in agreement with whatever it is that, for instance, if someone petitions to probate a will in probate court, and the other family members are in agreement with that petition being filed with the court, because the initial petition is asking for that individual, the petitioner, to be appointed as the representative of the estate. If the heirs at law are in agreement with that person serving as a personal representative, then there would not be any need to attend the court hearing. They can sign waivers in advance and consents and answers and file that with the court, and they could be excused from the court hearing. That's in our jurisdiction. That's most jurisdictions. I would always just err on the side of caution and tell everyone to check with the court and ensure that the court is not requiring their attendance. If someone is served with a subpoena to appear in court, they have to appear in court regardless of whether they want to be there or not. If they receive a subpoena, they have to be there. And so that's, if you're represented by a lawyer, always ask your lawyer. If your lawyer tells you to be there, listen to your lawyer, do what your lawyer tells you to do. If you're not in agreement with whatever it is that's being asked for before the judge, then you absolutely do want to attend the hearing, regardless of whether or not you have a lawyer. You want to make sure that you attend so that your voice can be heard and you can let the judge know that you're not in agreement, why you're not in agreement. And so under those circumstances, you absolutely do need to ensure that you're in attendance.
Okay, awesome. So let's talk about if they don't have an attorney, which I'm sure happens a lot. I know a lot of people that I work with, I would say a good percentage of them do not have an attorney. So that person, if they're not in agreement with it and they come to court, what advice would you give them, if any advice?
I would strongly encourage them to consult with an attorney to discuss their options. Even if they can't afford to hire a lawyer, if they can just afford to pay the consultation fee to be able to go in and sit down with a lawyer and discuss the case with the lawyer and get some feedback on that, I would certainly highly recommend they do that. In the event they can't afford to hire a lawyer, at least consult with the lawyer regarding the case, get some guidance from that lawyer to know what to do. But if they do not have a lawyer, they want to go to court because they're not in agreement, they need to go to the court prior to it, well in advance of the hearing. They need to ensure that they have a copy of the pleadings that have been filed with the court. If there have been petitions, motions, things of that sort that have been filed. If there are pleadings that have been filed with the court that they disagree with, they need to file a response. It can be as simple as writing it on a sheet of paper. Make sure you put the style of the case number, and then, dear judge, I'm writing to let you know I received a copy of this motion. I do not agree with this motion. I would like for this to be set for a hearing. I would like an opportunity to be heard at this hearing. That's the number one thing. They need to ensure that they have a copy of all the pleadings, because there are times that motions are filed with the court and then you get to court and no one has responded. And so if you haven't responded, there are times those motions are granted because there has been no objections filed. So that is important to ensure that. And did you ask me what we need to do to prepare for court?
Yes.
Okay, I was making sure I didn't want to get too far off track. So that's the first thing. I'm sorry.
I was going to say you can answer that, but I wanted to piggyback on something that you just said, because you're saying that the person should at least answer it. And, you gave details of how simple the response can be. And I'm glad you said that, because I think a lot of people feel like because they don't know what to do, that's why they don't respond to the paperwork.
And what happens is when someone files a petition with the court and there are service requirements, and it depends on each case as to who's required to be served with a copy of that petition. And so they send this out to serve those individuals. When those individuals are served, there should be a summons attached to the petition that says you're being served. You have X number of days to respond. Generally in probate court, we have 30 days to respond. However, there are exceptions. There are cases to where a deadline to respond is 14 days. There are times a deadline to respond is 7 days. A deadline to respond is 10 days. Make sure you pay attention to that summons that you're served with, and it tells you how long you have to respond. If you don't have a lawyer, write it down on a sheet of paper, take it to the court, file it with the court, because your failure to respond, and not only your failure to respond, but your failure to respond timely, can result in the petitioner, once they prove that you've been served and then there's been no answer filed, they could proceed with filing an application for a default judgment, and they can get a default judgment, and that would mean basically everything they've asked for in their petition is going to be granted. Wow. And there are ways to ask for a default judgment to be set aside, but there are specific elements that have to be met, and not everyone meets those elements. So if you've missed your deadline to file an answer and a default judgment is entered against you, there's no guarantee that you're going to be able to get that set aside and vacated. So it's very important. If you go consult with an attorney, that you're intending to hire an attorney, but yet, you're having to save up or come up with the money to do that. You've got a deadline. As I said, take a sheet of paper up there and just say, I deny the allegations. I don't agree. Something that simple, file it. If you do hire a lawyer, your lawyer can come in and file an amended answer and answer it the way that, an attorney would file an answer, but they can amend it and still accomplish the same thing you need to be accomplished. But it also protects your rights.
Awesome. That's good information. So my next question is, what should we do in advance to prepare for this probate hearing?
As I said earlier, get a copy of the pleadings, get a copy of what's been filed with the court. If you don't live close to the courthouse, a lot of jurisdictions have electronic access to court files now. And so if you got to drive a couple hours to get to the courthouse to get those documents, call the clerk, ask the clerk, how can I get a copy of this? Whether they give you, the information you need to be able to access these documents electronically. There generally is a fee, a small fee for that. Or, ask them if that's something that they could mail to you because of the distance. They won't always do that. Generally, they want you to come there in person and show your identification if they don't have electronic access. But if you explain to them that there's a distance, a significant distance between you and the courthouse, then sometimes they will mail those to you. The other option is also to call the other lawyer and ask that, whichever lawyers represent the petitioner, call that lawyer and ask that lawyer to email you a copy of the documents that have been filed in the case. make sure you have those, you carry those pleadings with you to court, so that when the judge is saying, okay, we're going to take up this petition, we're going to take up this motion, we're going to take up this motion, you're able to look at each one of those documents as the judge is addressing those documents, and you've got them in front of you so that you can follow along when the court is discussing that, or when the attorneys are making those arguments on those pleadings. That's important. That's one of the most important things to do. Secondly, if you've exchanged text messages with, other family members, or or maybe not even just family members, with anyone, if you've exchanged text messages that are important, that are relevant to the situation before the court, you want to screenshot those text messages. And what I always tell clients, when you start screenshotting, make sure the last sentence on this screenshot is the first sentence on the next screenshot. You show the flow of the conversation. That way it shows that there was no parts of that left out. It's there in its entirety. The other thing is, a lot of our phones, I'm not an iPhone user, but I know a lot of the iPhones, if you look at it, it'll show a message was sent Monday, a message was sent Tuesday. I always say go in and screenshot it, just so you can make sure you have a backup copy, but always go back once your phone tells you the date and the time. So when you start screenshotting, start where the date and the time is, even if the beginning part of that conversation is irrelevant. If later the latter part of that conversation is relevant, you want to start with the date and the time, because that's important for authentication purposes, to show the date and the time, and then to show the entire flow of the conversation. So if you have, there are apps that are out there that you can purchase for a small fee, that you can download, connect your phone to your computer. It puts it all in a PDF format. If you can afford to do that, that is phenomenal. Us lawyers really enjoy that. I do, especially. If there are Facebook messages, we get a lot of evidence on social media these days. Social media can make or break your case. If you're seeing things posted on Facebook or Snapchat, or whatever other social media sites are out there that may be relevant to the issues at hand, screenshot those. If it's videos, make sure you do the screen recording on your phone, record the video in its entirety. Make sure you show the person's profile, to where it's identifying, not just go on there and see the video, but also in your screen recording, you scroll through there and show the person's profile, and then come down and record the video, whatever it may be. If you've exchanged emails, if you have medical records or bank records, anything of that sort that you believe is going to be relevant to the issues at hand, have every bit of that prepared. Make copies, have a copy for yourself, have a copy to present to the court, have a copy to present to opposing counsel. And so you need to be able to have your copy, so that once you give a copy to the court, you give a copy to opposing counsel, you also have your copy that you're able to sit there and sort through while you're asking witnesses questions.
This is so good. I feel like I'm in probate court hearing class 101. I mean, really.
Sorry. I've just been doing this so long. It's just second nature to me.
I love it because you're so thorough. I will say this. I don't know why you're not an iPhone user. God bless you, though. I'm kidding. All right, let's see. What was my next question? Okay, here's a simple question, but I have got to ask this. How should we dress, and how should we address the judge when we are in court?
And one thing I want to back up and say to finish out how you prepare for court, and it kind of goes with this as well, get there on time. If you can get there, 15 minutes early, that's always preferred. Make sure you're there. And one other thing is, reach out to the other attorney and say, hey, we've got court next week. I wanted to call and discuss this with you and see if there's any way we can reach an agreement about this.
Wow.
It's always good to reach out to opposing counsel or opposing party and see if we may have 10 issues. We may not be able to settle all 10, but we might be able to settle 4, or we might be able to settle 6. We might be able to settle some of the issues and not all. Sometimes you can settle all of them. That helps to reduce your prep time. It also helps to reduce the time that you're going to spend in trial. When you get to court, different courts required to have different standards as far as their attire. It's not as stringent as it was years ago. I remember when I first got in the legal field 26 years ago, it was still what I call old school, and you were expected to come into court with suit and tie and appropriate dress shoes. And federal courts, I think, still require you to come to court with closed toe shoes, and you're not, they don't want you wearing open toe shoes in the court. You don't have to come to court in a suit and tie, but I would say dress appropriately. Wear a pair of khakis, wear a button up, wear a polo shirt, some decent shoes. You don't have to go out and go shopping just to have clothes to wear to court. I would talk to clients and they're like, oh, well, I'm on my way to, I'm going to buy a new outfit to wear to court. And I'm like, well, you don't have to go shopping and have a new outfit to come to court, but dress presentable. How you dress affects how you feel. It just, your whole appearance really, it's also a confidence booster. If you're dressed nicely, you're dressed decently, you're going to feel better about yourself. You're going to present better when you get to where you're going. Like I said, you don't have to run out and buy new clothes, but just wear a pair of khakis, wear something you would wear to church, a button up top. Ladies, if you want to wear a dress, that's good too. Please don't have them too short. We're not headed out to a dance. We are headed to court. So make sure your dresses are an appropriate length. I always go back to when we were in school. They would tell us it couldn't be 3.5 inches above the middle of your knee. That's a good guidance for when you're going into a courtroom. Right. And always address not only the judge, but everyone in the courtroom. Always address them with respect. Yes, ma'am. No, ma'am. Judge, when I'm speaking to the judge, sometimes I'm like, Judge, do you mind? Or Your Honor. I try to address the court with Your Honor as much as possible. There are times where it just comes out, hey, Judge, and then there's times it's, hey, Your Honor. But I really, my preference is always Your Honor. If you disagree with the judge, which happens, that happens a lot, my thing is when I disagree with the court, I'll say, Judge, with all due respect, Your Honor, I respectfully disagree. And so regardless of whether you agree or you don't agree, you still handle it with dignity and with respect, and you always respect the other party. Of course, we come in, a lot of parties come into court, they look at their husband's attorney or their wife's attorney or, whoever's on the opposing side, and, well, I don't like them. They have that misconception. They don't like that lawyer because that lawyer is representing opposing party, and they lose sight that lawyer is doing their job. They're not there to take it personal or to have any personal vendetta. They're doing the job they were hired to do. Treat them with respect. Yes, ma'am, no, ma'am, yes, sir, no, sir. And again, just be kind. Wait for you. If the judge is speaking, allow the judge to finish, and not just the judge, but if another party or the attorney is speaking, allow them to finish saying what they're going to say. And once they have finished, then you get to say what you want to say. There are times even, that could be a problem in the courtroom, and it depends on the judge sitting on the bench. And so there have been times I've been in the courtroom and I've just kind of held my hands up. I'm not like this, like I was in school, but I'll just kind of hold my hand up, and I watch the judge. And when I see that the judge sees that I've got my hand up, that means there's something I want to say. And once I realize the judge acknowledges that, then I'll put my hand down. And then once we get to a breaking point, then judge will look at me and, hey, Miss Millwood, go ahead and say what you need to say. That generally always works without a problem.
That's good. Good information. I think it's good too that we make eye contact with people.
Absolutely.
Yes. Mm-hmm.
And one thing, and I just recently had a client to ask me this. In our courtroom, we have the judge up on the bench. To the left of the judge is the witness chair. And so when the witness is sitting in the chair, the judge is on their side. And,
Mhm.
and they said, hey, am I supposed to be looking at the judge when I'm answering questions or looking at the person asking me? Generally, you're looking at the person who's asking you questions.
Mhm.
There are times that you would look at the judge, but generally not, because the judge is to your side. If the judge is asking you questions, then yes, you want to turn and face the judge and speak directly to the judge.
Mhm. Awesome. I want to go ahead and just discuss the fact that you are actually running for a probate judge in Calhoun County, Alabama. I think you're going to make an awesome judge. Notice I said you're going to
Thank you. I appreciate that.
judge.
Appreciate
So let's talk about, that somewhat. You already talked about how you are qualified as far as, your experience, but from the conversation that I had with you prior to this, when I first met you, I was blessed to know that you are passionate about people and you're passionate about the community.
Yes, ma'am.
Yes.
Um, so our current judge is finishing out her term. This is her third term, and she's finishing out her term, and she's going to vacate her seat. She's not going to run again. And so we have a vacant seat, and I am on a mission to protect the bench. In Alabama, probate judges are not required to be licensed lawyers.
Mm.
They are for other judges, but not for probate judges. Some counties have passed local ordinances, but as far as statewide, they're not required. I think it's absolutely critical that we have a licensed lawyer serving as our probate judge, and not just a licensed lawyer, but someone who has experience.
Mm.
And as I said, previously, I've been in this field for 26 years. I've devoted my life to it. I intend to devote the rest of my life to the legal field. It's where my passion is. It's what I enjoy doing. And so I want to make sure that I'm able to protect the bench and have a person there that is going to be able to, and with my experience, I've handled a lot of probate cases. I always have probate cases pending before the court. Like, can't tell you a time in the last 14 years that I have not had a case pending in probate court. So I'm able to walk in on day one and pick right up where our judge leaves off,
Love.
because I've handled every aspect of our probate judge's duties when it comes to legal matters. And there's nothing that I haven't done. So I'm able to just walk right in and just pick up on day one and never miss a beat.
Mhm. Mhm. Um, I just want to say this as far as me, my life. I'm a volunteer in the prison system. And a lot of times throughout these decades that I've done that, Shirley, I have met, you know, inmates, family members, and so many different scenarios or situations that people have gone through with their trials and their sentences. And I always tell them, make sure you're praying for those that are in authority. Pray for the judges, pray for the attorneys, pray for the probation officers, so it's the same, in probate. Pray for the judges, the probate judges. So I'm glad to know that since I know you personally, that you have, again, that you have a passion for what you do. And so I'm excited for you.
Every morning when I get up and I'm getting ready for trial, I do the same thing. I pray about it and just ask God to have His hand in that day, and for all of us, like not just myself, but
Mhm.
for our judge who is making these decisions, because they're tough decisions.
Right.
Um, the ones that everyone's in agreement on are obviously the easy decisions, and we love those.
Mhm.
But those ones where we have a lot of discrepancies, judges have to make tough decisions. And our probate judge has the duties and obligations to make rulings that will affect people's constitutional rights.
Mhm.
And I think sometimes people tend to overlook that, because they kind of see probate judge, they think of recording deeds and more real estate type deals. But the probate judge presides over adoptions, conservatorships, guardianships, involuntary commitment proceedings, eminent domains, all of those things that will infringe upon or terminate or sever a person's constitutional rights.
Right. And I think it's important too, because we can go ahead and talk about it, because this is one of the points that I wanted to make here on this broadcast, is that the probate judge also has to realize and be sensitive to the fact that that person in that courtroom is probably still grieving the loss of their loved one.
And in grief, whenever we experience the loss of a loved one, our body goes into shock. And we have that shock acts as it's like a shock absorbent. The shock protects our body from completely feeling that. I know it's kind of it's hard for me to explain it, but I've read it and studied it. And so with that, when you're first losing a loved one, you also have a lot of brain fog. You have some memory loss. And those things eventually come back over time, but initially they're not. And so what you deal with is, when you lose a loved one, you're having to go in and probate a will, or you're having to go in and probate an estate, and you're doing this all while you're grieving, and all of this shock is still there, and the grief is still there. And so you're very emotional. I call it an emotional roller coaster, because your emotions are all over the place. You have a tendency to say things or do things or act in a way that you normally wouldn't, because of that grief. And dealing with probate court is dealing with a lot of death. Sadly, but it is what it is. And that's where, my experiences helped me to be able to be more compassionate in that area. I've lost my child 5 years ago, and learning to navigate that grief journey, beginning 5 years ago, has taught me a lot. And so the first thing I did was sit down and educated myself, because I entered into a new area, an unknown area for me. And so I had to sit down and educate myself on that. So I've really studied that a lot, and, just a lot, and devoted a lot of time to that. And so having, and of course I've lost other loved ones as well, my parents, my step parents, and so we, all my grandparents, aunts, uncles, those types of things. So I've dealt with a lot of loss. I deal with grief. There's something, losing a child is something you never get over. You just learn to work through it. And so it's something that it never really gets better, and you never really get over it. And so that's just something that I had to learn is going to be a part of my daily life for the rest of my life. But anyway, having gone through that puts me in that position to where, when someone comes in the courtroom and they're upset or they're emotional and these things are going on, I'm not just going to automatically look at them and say, "Oh, you're just, you're just being a brat," or whatever. I'm not going to be in that position to do that. Like, I'm going to look at them and be able to empathize or sympathize with them, to know that, you probably wouldn't act this way, or you probably wouldn't have said that if you weren't riding this emotional roller coaster that you're currently riding right now.
So good, so good. And when you mentioned you losing your son 5 years ago, I want everyone to know that's watching that we'll be actually doing another interview in 2 weeks live here, discussing that topic. So stay tuned to this channel, and while you're watching, be sure to share the video, share it with your family, friends that need this information, even if they're not in a probate situation right now. Probate at some point will touch everybody's life. Maybe not us individually if we have all of our affairs in order. If you have a trust, you may not have to go to probate court, but you do know someone that will need this information. So please share the video.
And one other thing I'd like to add is, if you don't have a will, that's important. A last will and testament allows you to have control over how your assets are distributed upon your death. If you don't have a will, and you pass away, we call that intestate. They've died intestate, and that means without a will. it is still possible to probate the will or, to administer the estate, but you have to file a petition for letters of administration. The petitioner is required to be bonded. They're required to file inventories with the court. You're going to spend more out-of-pocket cost, more time, more headache. The judge is going to have to set it for a hearing. You're going to have a hearing. The other thing is that your assets are then distributed pursuant to the state law. And not everybody wants that. So if you don't want that to happen, then the very best thing you can do is to make sure that you have a last will and testament before, as soon as you can, because none of us are guaranteed tomorrow. Have a last will and testament. That allows you to control the distribution of your assets upon your death.
And that's definitely, of course, a service that you provide at your office, correct?
Oh, yes, ma'am. I can't even tell you how many thousands of wills I've prepared. Yes, ma'am. Yes, ma'am.
Yes. Just want to make sure they know. And I will have Shirley's contact information here. Here's her website, and I will have her phone number, and I will definitely put it in the description area of this video. But I want to talk about now contested cases. What advice do you have for siblings? Two sisters, let's just make an example. Two sisters, mother passed away. They just are going head to head and cannot come to terms as to agreeing what they want to do regarding their mother's affairs. And I'm asking this question because a lot of times I deal with attorneys, probate attorneys, and a lot of them, Shirley, they're saying they no longer handle contested cases because it's so difficult.
Yes. And I think the best piece of advice that I could give someone is back up, take a deep breath, spend some time in solitude, spend some time doing some soul searching, and, think about what it really is that you're fighting over. Are you fighting over, obviously you're fighting over material goods. Why are you fighting over those material goods? Is it because they're sentimental? Is it because they're valuable? Are you figure out the reasons why you're fighting? Because what we see so often, and it's really sad, we see families who are close-knit families. They, their matriarch passes away, whether it's grandmother, mom, dad, whoever it may be, that matriarch passes away. And then all of a sudden the families start fighting. And there are times that when enough years pass, those families are able to work through that and mend that brokenness that was caused. But then there are a lot of times that brokenness remains for a lifetime and they're never able to save that. So my best piece of advice is stop and think about what it is that you're really fighting for. And if what you're fighting for, is it really worth you throwing away your family or your sister, for the rest of your life and not having your sister there? Because one thing about material goods is we're not taking them with us.
That's right.
When we leave here, we're leaving them for someone else. They're not going with us. So is it really worth it? But if it is, and you're going to continue it, and we deal with this all the time, that's what keeps us lawyers in business, is, so if there's a will, that will is going to determine the division or the distribution of assets. So then it's asking yourself, are you fighting for something that, your mother has chosen in her will to leave to your sister? Are you now disagreeing with your mother's wishes and saying, well, mom left that to my sister, but you know what? I want it. And so I'm going to fight for it. Ask yourself that, because you may be spending money to fight for something that you're going to end up losing in the end. And if it is mom passed away without a will, then the state law directs the distribution of those assets. The other thing is, if you get to a point you just can't agree, ask the court to sell it. The court can order property to be sold, personal property, real estate property. They can order it to be sold and the money deposited into the court, and then the court can determine the distribution of the assets based upon the laws of the state. What you run into is, in those situations, You end up with a guardian ad litem being appointed. You end up with a court representative sometimes being appointed, conservatorship or conservator. So you end up with court representatives who get appointed in these cases, and guess who pays them? Not the state.
Wow.
So start thinking about how much are you fighting over $2,000? Well, I can promise you, you're going to spend more than $2,000.
Wow. So it's not worth it.
Right. Right. So you really need to determine the value of the estate to determine if it's even worth fighting over, and determine what your expenses are. One thing that we see a lot is when there is a will contest is, hey, mama had dementia and mama didn't know what she was doing when she signed that will. That's a legitimate reason to contest a will, especially if it's completely one-sided and you know that mama had dementia. Then in that case, whenever you contest that estate administration in probate court, it should be transferred over to the circuit court. When it gets to the circuit court, you have the option of having a trial by the judge or requesting a trial by jury. And I've actually tried a jury case with a contested will. It was, in fact, my very first jury trial was a will contest case. And unless you can come in and prove that the testatrix or the testator signed that will under duress, or that it was done fraudulently, or that they didn't have the mental capacitation to do that, you're not going to be successful. You've got to prove those elements, that they were under duress, they were forced to do this, or that they were not mentally competent. And so if you can prove that, then what you do is, with that, you're able to get that will voided as if it never existed. Then the distribution of assets revert back to how the state law determines those to be distributed, as if there was no will.
Wow. Wow. You have a lot going on every day, huh?
Yes, ma'am. Yes, ma'am.
Wow. It's so fascinating to me. So my next question is, what constitutes a valid will in Alabama? And I'm asking this because I'm licensed in multiple states to sell real estate, but every state, the will is different. So what is it for Alabama?
So for it to be a self-proving will, there has to be 2 witnesses and a notary. The 2 witnesses have to witness the testator or testatrix executing the will. The notary has to witness the testator or testatrix executing the will, and also witness the witnesses signing the will and witnessing that signature. So two witnesses and a notary, and then that's a self-proving will.
Okay, awesome. Awesome. Well, this has been great. Do you have anything else that you want to add?
Let me look at my notes real quick. I don't think so. Just to look, see if I had missed anything. One thing that I didn't mention is, when someone files a petition to probate a will, they have to provide a copy, or at least here in Alabama, they have to provide a copy of that petition and a copy of the will to each heir at law. And it may be that whoever's prepared, or the deceased person, when they prepared their will, they specifically disinherited, certain individuals in their family, and maybe they're leaving everything to one individual and then disinherited the others. Even if those heirs at law have been disinherited and are not subject to receive anything, they still have to be served with a copy of the petition and a copy of the will. So if you are an heir, you should be receiving that from the attorney who's filing that petition. And you have to have that. And then either, you get a copy of the order that says when the court hearing is, you show up there to contest the will. I mean, I would prefer you file something in advance, but also show up at that court hearing If you don't have any objections to it, then you don't have to respond. You can just let them do their thing. So you shouldn't have to bring a copy of that will with you to the court, because the court is going to have that.
Awesome. Are the Alabama probate records maintained online for the public?
Sort of. That is something that has been in the works. There is a website we can go to, and some of the counties have been participating in that to make the records available online, but not all counties are up to speed with that yet.
Okay.
Now, statewide, as far as circuit court, district court, all of those records are electronic. In our federal courts, they're all electronic, but probate courts are catching up to that.
Okay, good. That's good to know. Well, thank you so much for joining me today. This has been so much knowledge. I appreciate it. I have learned so much myself. I look forward to part 2 in a
Yes,
few
ma'am.
weeks.
Well, thank you for having me.
Yes, thank you so much. And to everyone that's watching, please share the video. And again, I want to honor attorney Shirley Millwood. Please make sure you check the description area for her phone number and her website if you'd like to get in contact with her. My name is Wanda Rochelle, and I welcome you, and I'll see you on the next video.
I have one correction real quick.
Yes.
It's my email address, not my website.
Oh, I'm sorry, email.
I don't even have a website. I know, like, I'm so far back, like everybody has a website these days, but
you're right. It is the email.
Yes.
App. And let me put that up for everyone. There it is. Perfect. That is your email address. I'm sorry, not website.
No, you're good. Thank you so much for having me. I've really enjoyed it.
You're welcome. Thank you, everyone. See you on the next video.
Yes, ma'am. Y'all have a great night. Bye-bye.